after you pass away.
And I guess another thing is that you haven't given guidance to your family through a will. You know, for example, I guess we'll talk a little bit later, but like burial instructions or how you want your funeral to be handled. There may be other details that you can provide a lot of information about in a will or in other documents that you prepare related to your estate plan. And they may be flying blind, and they're making decisions, you know, again, without the benefit of your guidance. And
yeah, and actually it can be worse than that, Michael. I mean, I see cases, because I also do probate, and,
yes.
and these intestate cases go through probate. But you have situations where you'll have people come in and one person will say, well, he told me this was what he was going to do, or she told me that was going to be left to me. And so you create expectations in people by what you say, and then if you haven't written it down, it doesn't necessarily happen that way. So it creates a lot of controversy sometimes.
People get mad.
Right.
Especially when you talk about money or heirlooms or
right.
what have you.
It creates family issues.
I was supposed to get grandma's ring.
Right.
Oh, Lord. Okay. So let's say you don't have a will again. How is an executor selected in that case?
Right. Well, actually, there isn't is not an executor if you don't have a will. There's some. It's called an administrator.
Okay.
Because when you're intestate, and what it requires is that somebody file a petition in the probate court to process your estate. If nobody does anything, and sometimes this happens as well, you have families who go through generations without ever really doing anything, and then you end up with title being in great-granddaddy's name, and if anybody actually wants to do something with the property at some point, they have a really large problem to solve because they've got probates going back several generations. So, but that happens. I've seen cases like that as well. But if somebody does file a petition for probate, which is what should happen, as long as there are assets that need to be probated, sometimes there are no assets that need to be probated. We'll talk about that also. But if there are assets that need to be probated, then someone should file a petition, and in that petition they ask that somebody be appointed the administrator. Probably the person filing the petition is asking to be appointed. If there's an argument about that, other people can also petition to be appointed in the same proceeding, and eventually the court decides, the judge decides who's going to be the administrator, or maybe co-administrators for an estate.
Right. So again, these things, one thing they can do is generate a lot of legal fees because of people disagreeing about who should be the administrator. And so again, if you have your will in place, you can simplify the whole process, even just with this one item that we're talking about. Having the
right. One of the main things you would do in a will, besides say who gets what and when do they get it, is to say who's in charge.
Yes.
And so you get to prioritize people. And again, the probate code has a priority for administrators based on how they're related to the person who died, and the closeness of relationship. And you can completely circumvent that system and name somebody who's not even related to you as your executor if you do it in a will. It still doesn't mean there won't be arguing about it. People can still argue. Yeah. But the priority that is given to the person you picked is very high priority, and it's almost sure to happen unless something's shown to be wrong with the person that you named.
Like if they were jailed for a felony or something.
Something like that. Yeah.
Okay. What are some considerations for small children? You know, for when you do or don't have a will.
Well, as I said, this is one of the main things people are concerned about in estate planning. Yeah. And one of the very first thing is who's going to have custody of your children. Right. If you have a surviving spouse, it's almost certainly going to be the surviving spouse, whether you even want that or not. But because they're a natural parent, again, unless there's a problem, that's probably going to be who has custody. But you know, you would want to name somebody that you would prefer, and so there's something called the nomination of guardian, where you get to nominate people that you prefer to have custody of your children, and those people are given higher priority than other people, other than the other natural parent. So that's one of the main things that people do in their estate planning, is to nominate guardians for their children. The other concern is, you know, children can't receive an estate if they're under the age of 18, and even if they are 18, that's not necessarily a particularly good time to start receiving substantial assets. So people will do even if they just do a will, oftentimes young couples that I work with will do what's called a contingent trust inside of their will. It's a testamentary trust, meaning it's a trust in a will, so that at the close of the probate proceeding, the money, if there's children, is funded, or the assets are funded to a trust, and you name a trustee of that trust, and then the trustee manages the assets for the benefit of your children until they're old enough. And you get to pick an age that's older than 18, so oftentimes they'll have a trust that runs until the children are 25 or 30 or whatever. And it will do things like pay for education and make sure they have housing and have what they need. But rather than trying to give it to them directly, which you really can't do, you put it into a trust for their benefit.
Right. And one thing, you may have somebody that you're really comfortable with as far as managing the assets, and you may have somebody else that you think would be a really great guardian for your children. They may be different people.
Right, and sometimes it's a good thing to have different people, as long as they can work together. You don't want any enemies, but it's kind of like, you know, watching each other a little bit, so that the person raising the children, you know, is concerned about their welfare and their well-being, but isn't spending the money. The person spending the money is concerned about investing the money and making sure that it's not wasted. So you've got kind of checks and balances a little bit if you can find the right people to do that.
Right. They don't have to be different people, but that's an option that you have.
Right.
Okay, so what are some other things you can do with a will, aside from naming an executor and setting up guardians for children and these trusts, for example, that we talked about?
Right. Oftentimes people say things in wills, like you mentioned, having burial instructions, but mostly that really refers to things like cremation.
Yes. That
can be controversial as well, and if you really want to have that, it's a good thing to say that. I believe it's a good thing to say in a will, but it's also it's extremely important that the people who are going to be in charge of your affairs after you pass away know that that's what you want.
Right.
Because they aren't necessarily going to see the will the first day.
Right.
So, you know, communicating with people about what you're doing and what you want is important if you can do that.
Yes.
But that's something you could include in a will. And then the other major thing that's done in wills is obviously not just the disposition of your major assets, but your personal assets. So like you mentioned, the grandma's ring, well, jewelry, furniture, those kinds of things are usually mentioned in a will as, you know, being left and who you're leaving them to.
Yeah. So these are like particularly, you know, like we say, the family heirlooms,
right,
that have a lot of high sentimental value.
Mostly it is, I mean, for some people it's real value, but for most people it's sentimental value. And that's really very important to people, you know, especially the people that are receiving the property, that you don't necessarily hear about this while the parents are alive, but the children all have ideas of what they want. And also, as I said before, what they think they're going to get.
Yes.
And so, again, communicating this is kind of important if you can do it.
Right. And in writing. So, anyway, okay. Okay, and we also talked about maybe disinheritance.
Right. Yeah, I mean, obviously, with an estate plan, as opposed to the probate code, you get to decide who you're going to leave your assets to. And so it's possible to leave your entire estate to a friend, somebody that isn't related to you in any way at all. You can leave it to charity. You can leave it, you know, to people in different percentages rather than equal shares. You need to be, you know, very careful about how that's done, which is why it's important to have a well-written document, because, again, it can lead to controversy if things are not what people expect. But you have the right to do that. You have the right to leave your estate. That's why it's called a will. It's what your will is. And if you want to disinherit particular people, you have the right to do that as well. And usually what goes along with that is a no contest clause. There's some new legislation on that issue. But the basic idea behind a no contest clause, which is very valid, is to say you put in a provision that says if you contest my will to your beneficiaries, then you get nothing. So if you have somebody who is going to get something, then they have a reason not to contest your will by doing that. So these are things you can put into documents that will make it more certain that things will happen the way you want them to.
Okay.